Welcome to CalOES Sexual Assault Training Standards, Materials, and Methods, session number 5. This is the last session in our series. So again, we're super thankful for all the folks who are here today to join us. We will be talking about Unit J, which is legal and court, as well as Unit K, which is agency procedures and requirements. So we'll be doing a deeper dive into both of these units in the CalOES training standards. Session 5 learning objectives. We are hoping that folks will be able to identify the training standards and requirements related to legal and court, also agency procedures and requirements, including those considerations for reporting requirements for your advocates. Secondly, we're hoping that folks will be able to describe strategies to achieve compliance with the training standards in both units J and K in the California Sexual Assault Training Standards Guide. So as always, like I said before, we'll be sending a survey out at the end of this, and please give us your feedback and let us know how we did in meeting those learning objectives. So this brings us to our first polling question. I'm going to go ahead and launch the poll. You can see the question up there on the screen. We'll be talking a lot about victim and survivor legal rights today, of course, as we talk about legal and court. So we see what folks' knowledge base is kind of going into this. So how many penal codes related to sexual assault should be addressed in the legal and court section of the sexual assault counselor training? So this will kind of depend to see if folks have already peeked ahead and looked through the standards, see how many penal codes are in there in Unit J specifically that are related to sexual assault. I'm going to go ahead and launch that question now. You should see it appearing on your screen. So we realize that a lot of folks here are probably guessing, but might be based off of how many penal codes, if you happen to know that number off the top of your head, that you're currently addressing in your sexual assault counselor training. So we're kind of seeing a pretty mixed bag coming through right now. We want to know, do you think it's 5 penal codes related to sexual assault, 8, 15, or 20? Ooh. So we don't have a ton of folks voting yet. We're at about 56%. As you know, we like to get to about 85% of the votes in. Signals that folks are thinking pretty hard about this question, might be taking a guess, which is totally okay. We're going to go ahead and close this poll in just a few seconds. So if you have not submitted your answer yet, please do. A reminder that this is anonymous, so we can't see who votes in which way.
Hey, I didn't know how many there were until Sarah told me, so.
So we're going to go ahead and close this poll in about 5, 4, 3, 2, 1. I'm going to share those results with everyone. You should see those on your screen right now. We have, like I said, a pretty mixed bag. Not many folks think it's 20. Most folks think it's 8, coming in at about 47%. Then we have 15, and then we have 20% thought it was 5. It is actually 15 penal codes. So those are all outlined for you in the training standards guide. We will not be doing a deep dive into all 15 of those penal codes today, but just to be aware, that's how many there are that we're going to be, recommending that folks look at in their sexual assault counselor trainings. And the training guide is kind of nice as well because it gives you sort of what the code is and does a pretty accessible, not full of legalese description about what it pertains to. It's all stuff that folks are familiar with. So yeah, Leah, did you want to say something?
I was going to say Mark is laughing, and so I'm thinking that he's thinking something particular about the penal codes. Mark, did you want to share?
No, I'm a volunteer at RISE, and my boss is in the training, and so I sent him a humorous text. So that's
okay.
That was it. So anyway.
Did your boss know how many there were? No, you don't have to put them out like that. I was like, hey, Sarah, how many are there? Yes, there are 15. Sorry. Go ahead.
Okay, this brings us to polling question number 2. Let's see, I'll go ahead and get that set up. So we'll also be talking today about pressing charges. There is a lot of I think, complication around this concept of pressing charges. Law and Order SVU didn't really do us a lot of favors in that regard. So we'd like to know what y'all know about it. I'm gonna launch the poll. You see that on your screen right now. So who decides, whose decision is it, whether or not to press charges in a sexual assault investigation? Is it up to the victim survivor, the district attorney, law enforcement, or all of the above? So we do have votes coming in quicker now, folks, to be a little bit more sure of this one than the penal codes. Understandably so. So we'll give folks a couple seconds to wrap up. If you have not participated and would like to, please do so now. I will be closing this poll in about 5, 4, 3, 2, and 1. So I'm sharing the results now. You should see those on your screen. 71% of folks thinks it is the district attorney alone who makes that decision. 18% think it's all of the above, and 12% think it is victim survivor. And as I anticipated, nobody thought it was law enforcement, which I said on our practice call this morning. I said, nobody's gonna pick law enforcement. So anyways, it is actually the district attorney who makes the decision about whether or not charges will be filed. Now, victim survivors might indicate a preference, of course, but ultimately that may or may not factor into this decision, but ultimately it's the district attorney's decision alone whether or not to file charges, since violent crimes are considered to be crimes against the state and not the individual. So it's important to help folks understand and make that distinction, because like I said, there's tends to be a lot of confusion and myths around this one. And all of the above is not necessarily a wrong answer. You know, these 3 different factors kind of work in tandem with one another, and they all have influence as to whether or not the decision gets made. But the answer that we were looking for in this situation was district attorney. So, you know, who ultimately is the deciding factor. Okay, thanks for playing our super fun polling game, folks. We are going to dive into Unit J, Legal and Court. The time to complete this unit is a minimum of 1.5 hours. Media allowable is 9 minutes. Of course, that is 10% of 1.5 hours. So that would be if you were to use 10% of media evenly distributed across all of these units. And this is one of our units that does, in fact, require a subject matter expert. So a note on that subject matter expert. As we said for medical and law enforcement, the unit will be presented in its entirety by the subject matter expert. So make sure that they're aware of those 15 penal codes. Often this is someone from the DA's office or another legal expert. Items 1 through 8 in the training standards still have to be covered. And the responsibility for ensuring that the subject matter expert does cover all those topics is on the facilitator. So of course, if they leave something out or there are additional questions, the facilitator will have to, you know, make up that information to make sure that everything is still being covered. These are our desired outcomes and key concepts for advocates. This is what we're hoping folks will walk away with after the completion of Unit J, Legal and Court. Advocates should be able to provide sufficient information about the court system and common legal terms, so some of that decoding to victim survivors to help them understand their rights and how the legal system works. So it's really important that advocates walk away from this unit feeling like they can talk somewhat intelligently about, you know, how the process works, perhaps who is the deciding person in terms of pressing charges and all of those kinds of nuanced pieces. Advocates should also be prepared to address the inevitable challenges faced in interacting with the complexities of the criminal legal system and cite examples of systemic inequities describing the impact on survivors' willingness to pursue prosecution, right? So interacting with the criminal legal system is never a quick and easy process. Like we mentioned before, there's a lot of myths around how well or how quickly the system works. So advocates really need to be able to, again, kind of speak intelligently about that and prepare advocates, or I'm sorry, prepare victim servers for that, as well as having a really deep understanding themselves of some of those systemic inequity pieces, as well as the complexities. Why do my slides keep jumping? Okay.
I'm telling you, there's goblins and ghosts in the machines today. We're not the only ones that are having this problem.
They're probably
A couple of other people,
It's almost
Olivia, Veronica, Gabrielle, we're all like, there's weird stuff that's happening. I'm telling you, I don't know if it's Elon Musk and the satellites or 5G. I don't know. Let's go with 5G. Oh, okay. So again, I just want to, we're gonna start where Sarah left off with, you know, your counselor advocates. Again, we talked about the back and forth between the counselor advocate, there's back and forth and straddling that. But key, very similar to medical and very similar to law enforcement. Key is that your advocates will need to be able to have an intelligent conversation with survivors about their rights as victims, right? About what they are entitled to in accordance with the state of California, right? Overarchingly, you want to make sure that your advocates can speak intelligently about number one, that their case may not ever go to trial. Like, they just got to keep it real with your with the survivors. May not ever go to trial, right? That if it does go to trial, there may be an acquittal, right? So, and that it is a long process. It is not something that is necessarily wrapped up very quickly, right? That, so you want them to, again, manage survivors' expectations, right? This may not go any further, and these are the reasons why it may not go any further, right? Or it may go, and you may not want it to go, and it may go ahead anyway because it is the district attorney who pursues the case, not the victims, right? So the victim can be an uncooperative witness, right? But nevertheless, you want your advocates to be able to kind of manage the expectations of the survivors about what may or may not happen. And that they, you know, and that it's been a long process, and this is the kind of thing that may actually happen in a courtroom proceeding, right? So you're managing their expectations. One of the ways that they can do that pretty cleanly is by referring to things like the what's going on in with regard to the penal code. So I would just want to draw your attention to a couple of the 15 that are in your training standards that are kind of going to be your go-to ones. And again, this is going to go on that little card that you're going to produce for your advocates when they're, you know, when you know, the courts open up again or what have you, when people go back out there, that's going to go in their info bag, right? You want to make sure that they understand that they are entitled, again, they are entitled to a crisis accompaniment advocate affiliated with a rape crisis center, but that they are also entitled to a support person to be present at preliminary hearings and through court proceedings and the like, right? Again, you have a right to have your counselor advocate be with you during every step of this proceeding, as well as a support person, right? Keeping in mind that when they are having a conversation with an assistant district attorney or anywhere in that with you present, again, that is no longer kind of like, you know, what they say to you, there's the privileged communication, that's kind of out of the, right? But that they are entitled to have two persons be there with them. They are also, statute of limitations no longer exists in the state of California, right? That got lifted somewhere around 2017, that they can file no matter how far back it was. So they may get someone that is calling on a hotline or chatting up through telehealth saying that this happened, and it happened, you know, 9 years ago, and they're really angry now, and they've had some time to think about it, and and they want to pursue, they want to, they want to make sure that there are some criminal proceedings gone after, right? So that statute of limitations are gone away. Then you want your advocates to, again, manage their expectations. Yes, you are right. This is your right to do this, and what have you. Know that this is what a district attorney, or this is what a prosecuting attorney is going to be looking for, right? So, but you want to, again, manage those expectations. But there are no more statute of limitations in the state of California. You also want to make sure that your advocates are able to have a conversation with victim survivors about credible witnesses, right? And how if someone wants to challenge the credibility of the survivor, or challenge the sexual history of the survivor, right? That is something that does not just happen in open court, but instead that there is a process where they must file motions with the judge in advance to determine whether it can be entered or not, right? So that they can't just start talking about their sexual history, but that it actually has to go through a motions process before anything like that gets introduced, right? So your survivors might be concerned about, well, we had a sexual relationship before, but this time we didn't want to, and what have you, right? So your advocate will need to put, well, actually, they can't do this, and if they do this, they have to go through this process, right? So you want to allay those kinds of fears, again, managing their expectations. Make sure that they have an understanding about what confidential communication is, and how it is configured within the legal court context. And remind them that they hold the privilege, and then as their advocate, they are not allowed to disclose that information without a release or a waiver on the part of the survivor, and what have you, right? So those are just some of the ones that are touched upon. Make sure that they have a good understanding overall, though, and that they can refer to any of these at any time, but these are the ones that are going to specifically are going to have a very close impact in terms of their ongoing engagement with survivors as they go through the legal and court process. Can we talk about common defenses of sexual assault? A little bit of that. So common defenses of sexual assault. Do you want to just do have the chats? I'm curious from all of you, like there are some common defenses that people will use, and your advocates should be prepared to have this conversation with the victim survivors, right? Just to let them know that this is what they're going to say when they get in the courtroom. That they're going to say that that you did consent and then you just changed your mind, that it wasn't me, something might have happened to you, but it wasn't the defendant that's in here at this point, that it didn't happen, or around capacity to give consent, right? Mental capacity, those kinds of things. I'm wondering though, it's just not funny, but I'm wondering, there might be some other very creative defenses out there, and we're just wondering if you could just drop in the chat what kinds of defenses that you may have heard in the past that people have used or that you've heard of. You just go ahead and feel free to drop it in the chat. I think, some of the most common ones are, she was on meth during the time, so she's not a credible witness. Survivor was drunk, so maybe they were both drunk. So how could, if we were both drunk, then how come, they get to claim that they were assaulted if both parties were drunk, or something like that. She actually did give consent, and now she's claiming that she didn't give consent. But the substance, under the influence is a very, very common one, right? Or that they changed their mind. There was consent and then they changed their mind, those kinds of things. Okay. Yeah. So she was on meth. That's, I'm not surprised, but that's the first time I've heard that one. Yeah. So your advocates are going to need to be able to kind of navigate your survivors' concerns or fears about things like previous consent, using substances or intoxication or inebriation or inability to give consent because of incapacitation, and those kinds of things. Oh dear, Katie. Oh dear. Because now there was other additional violence in addition to the sexual violence. There was physical violence and cutting and bruising and that kind of thing. But because the survivor was on meth at the time, the DA dropped the case. They didn't know the victim was underage. She looked older, or he looked older. They looked older. Yeah, that's a I don't know how common that is anymore, but it used to be far more common, I think, out there. But with Katie's case, that is, again, it's up to the district attorney to determine whether they're going to move forward or not. And a lot of it has to do with the credibility of the witness, right? When we talked about how we, in our field, we refer to them as survivors, medical professionals refer to them as patients, law enforcement officers refer to them as victims, but the DA's office refers to them as witnesses. As far as the district attorney or the state of California is concerned, the people that your rape survivors are witnesses to a crime, right? And their body is where the crime took place, right? So they have to be, as far as the district attorney is concerned, they have to be credible. They have to be credible witnesses, so that the district attorney feels like they're actually going to win the case. If they don't feel like they can win the case, they will not move forward with it, right? So it's unfortunate, but those are the kinds of things, again, that your advocates will need to manage those expectations for, help your victim survivors manage those expectations. So how old was the victim? We got to add that one to the list. Sarah, they looked older. Okay. All right, very good. Thank you for that. During proceedings, right? During proceedings, you want to make sure that your counselor advocate is able to, again, intelligently explain the process. There are going to be preliminary hearings, and then there's going to be this kind of a hearing, and then you do not have to show up for this kind of a hearing, but you do want to show up for that kind of a hearing. You want to participate, right? If they are willingly and willingly engaged in the process, right? So you don't want people to, people may be reluctant, sure, but they should not be forced or compelled, right? If they don't want to show up, they don't want to show up. But again, you want your advocates to be able to intelligently explain the process and keep them informed. Now, this is what's going to happen next. Oh, well, they did this because of that, right? So you want to make sure that they, as part of your role plays, even practice thinking about what are the various processes that they can expect as they go through criminal legal, the court process, the court system. And always providing support. There's going to be a need to provide a lot of support, and there will be family members around, or there will be friends, other support persons involved. So the advocate will need to manage their presence, right, in that space, depending on who the survivor has brought along or asked to come along for support. So the advocate's going to have to really know their place and maintain appropriate professional boundaries. Again, they are representatives of your organizations. So you want to make sure that they are understanding that it's going to be kind of fluid. They're going to step in, they're going to step out, and there are going to be times when the survivor is going to be able to focus with them and not be focused. And your advocates, again, will need to be in tune to what is happening with the survivor in terms of how engaged they can be at any moment in time, right? So that's the role of your advocate. So provide support. They'll also want to make sure that they can talk intelligently about things like restraining orders, different remedies. Are we going to talk about going through the civil court system also? Is that next? Is that the next slide,
Yes,
Sarah?
I think so.
Okay, so let's go to the next slide. And your advocate should be able to have a conversation with survivors about alternatives, right? So if the district attorney decides not to carry the case forward, or a city attorney, depending on how egregious the offense is, if the prosecuting folks decide not to take it forward through the legal court system, criminal, that they can engage with civil remedies, right? That they can take them to sue them in civil court. There are differences, right, in terms of evidence, level of proof or evidence for that claim. You do not have to have beyond reasonable doubt when you're in civil court. You just have to have preponderance of evidence when you're in civil court, right? And that's like 51%, like I'm 51% sure, 51% sure that this person actually did commit this crime, that this claim is being lodged against them, right? So it's not as, the bar is a lot higher in the criminal courts, and the bar is a little lower in the civil courts, right? So there are limits, I believe, to when you can start launching a civil claim, right? So while there's no statute of limitations in terms of criminal court proceedings, there might be limitations in terms of filing civil claims, but civil court is an option, right? So your advocates will need to be able to present that as an option for the survivors. Yeah, you got to pay for your own attorney. That's for sure. If you're going to civil court, they do need to have money to pay for their own attorney, right? So that's a good point. Thank you, Amanda, for bringing that up. Restraining orders are also an option. They are filed through the civil process. So you may need to get a private attorney to do that also, but you want to make sure that your advocates are able to. I'm sorry, I am just melting here in Southern California. It's like 100 degrees here. My apologies. So you want to make sure that your advocates are able to break that kind of information down for them as well. And if they don't know it all off the top of their head, they have to be able to get that resource for the survivors and make sure that they share that information with them. And again, let them know what their options are. Again, overall managing and supporting, while supporting the survivor, managing those expectations of what is available to them. Okay, we can go to the next slide. Okay, so coordinating with victim witness and other entities like that. So how many of you, if you are just drop in the chat if you could, if you have a sec, how many of you engage with your local victim witness offices, or at least before COVID-19, engage with your victim witness offices? Do you have a good relationship with victim witness? Do you like those folks? Do you tend to refer to them? Do you find that the people in your community have a good experience with victim witness? Great partnership. Okay, Jose, good. So you have a good relationship with them. Good relationship. Let their clients know they are not confidential. That's a key. That's key. That's really important. Some are better than others. Isn't that always the case? It is so key that that is one of the primary things that you want to make sure that your advocates are able to make a distinction with the survivors, is that should they go the victims comp route, that the victims compensation folks are not confidential advocates, right? And so you want to make sure that they understand that what they're sharing with the victims compensation folks or victims comp folks is not protected, okay? You want to, I think that we all want to make sure that we want to have good working relationships with the victims comp people, but your advocates should know that in order to be eligible or apply for victims comp, that they must file a police report, right? Or there must be a medical report, which will then trigger a police report. So if they go to the hospital or if they go to the cops first, having either one of those will be necessary for going through the victims comp process. Okay, doesn't mean, of course, the case ever has to go to trial. Doesn't mean it ever has to go all the way through the end. They just have to file the police report in order to be eligible for the victim's compensation, right? So you want to make sure that your advocates are able to make that distinction, because you know people are going to be like, oh, I don't want the cops to know, but I need some relief over here, and I need some assistance over here, and we need some advocacy in these other ways, and they should not. Let me see how you're going to phrase this. They should be able to take advantage of those resources, right? So the degree to which your advocates can allay any concerns about going through the system that way and filing their police report, or going going to a medical professional and getting that kind of an exam done, a forensic exam done, either one of those, that's pretty much all they need as evidence to be able to, or to support their victim's comp claim, okay? It's not contingent upon actually going all the way through the criminal criminal justice process. A couple of comments over here. Good relationships with your victims comp folks, partner all the time. And it's good. It's good that your advocates or that your organizations have good relationships with them. Do your court counselor advocates, are they the ones that work with victims comp? Or is it a staff advocate that works, like, do you have staff that work specifically with victims compensation? I'm just trying to gauge, again, with advocates, what level of, quote, professionalism do you all require to really engage with, like, victims comp? So it's staff. Yeah, that's pretty consistent. Okay, good. Okay, good. Oh, everyone in the agency from crisis line to therapists. Okay, so anyone who's employed with the organization, yeah. It's been so long since I went through crisis advocate training. Volunteers, we were all volunteers, and volunteers did everything. We did all the court accompaniment, we did all the work with victims compensation, we did the hospital. But as over the years, and as things have become more complex or maybe complicated, it is a lot of that kind of work has shifted internally to staff primarily, and in some instances it depends on who has the relationship with the survivor. This is also going to be reflective of whether your organization and your advocacy is what they call the vertical model or the non-vertical model, right? So you have one advocate that does perform one type of service, and then maybe you will do a warm handoff to someone else in your organization who does legal advocacy in your organization for the non-vertical model, right? And so again, your advocate, whoever, if it's staff or if you have semi or paraprofessional folks doing this kind of work, again, they'll want to make sure that they're doing a warm handoff if it's non-vertical. Or they're, sticking with them throughout the whole thing. Okay, so let's go to the next slide. Okay.
So we're going to get into some breakout rooms, which is great. We are right on track with time here. Gotta love when that happens. So we're going to put you into breakout rooms of about, let's say, like 4 or 5 people. And we're going to put folks in there for about 7 minutes. And we're going to invite you just to talk a little bit about what are some challenges or successes that advocates have encountered in legal/court advocacy and accompaniment.
Yeah.
So we now know that I have to stop sharing my screen for some reason to do breakout rooms. So let me get us situated. So also drop this in the chat too, so then y'all should be able to see it when you're in your breakouts.
Oh, great.
Okay, so here we go. I'm going to open up the room. You should get an invitation to join on your screen. So we will see you back here in 7 minutes. Leah, did you want to add something?
Nope.
Okay.
Just that they're all about to be Harry Pottered.
Yes, that's exactly how it works. Same
Whoop.
method. So are folks able to assign reporters in their breakout rooms to do kind of a quick round of share outs before we go on our break? Do we have a couple of folks who are willing to share what you discussed in your breakout rooms related to successes and challenges of legal and court advocacy and accompaniment?
I can go. I'm for group 7. So kind of what we discussed is some of the challenges we faced have been just kind of being able to either be on, like we get a little bit of pushback on being available to be on the witness stand like during court. So we've coordinated to kind of sit out in, you know, where like the supporters are, and just kind of explain to our survivors in a different way, just that, you know, they'll be able to face us and we can be their safe space. And they've become a little bit more comfortable depending on how it's explained to them, since, you know, it's not always so welcoming to sit on the witness stand with them.
Mm.
From my group, it was actually one of the coordinators that are from my my organization. So she explained to me that sometimes it's good to have like the child be shown like the court by itself with no one in there first. That way they don't feel as nervous and they know their surroundings and their environment. Before they're actually going in there with a bunch of people that they do not know.
Mm. Oh my goodness, that is really scary. That's really important. So important.
I'll report back from our group. So I think we were talking about, like, you know, when advocates are actually trying to advocate, like we can only advocate so much, and ultimately like this other system is making a lot of decisions and we're just really trying to be there for the survivor. Like we can advocate, but we may not change the outcome. And then I think for like the training portion of it, we said that it can be hard when advocates like focus on really like minor parts of the legal system instead of like, we really need to do big picture stuff in the training, like big differences between like civil and legal, and not get into some of the like really small details that, you know, volunteers might want to focus on. Like I use the example of pleading to the sheet. Our training spent 20 minutes talking about that, even though that wasn't really something we're talking to our survivors much about. So trying to keep the focus like in a balanced way during the training.
Good. I have a question. Do you all find that in your trainings that your advocate trainees are really nervous about this aspect of being an advocate, having to work or engage with or interact with the legal criminal process?
Leah, this is Sonia. I could say that it isn't always like that, but we had a training, maybe the last training or the one before that, where we definitely had somebody in there that had a lot of bad experiences with law enforcement, and she was just the anxiety of coming up, you know, because she was very much like, you know, well, you know, I hate cops, you know, and then she would tell other people, and, you know, so we had to like, you know, we had to take care of that. So sometimes you will find people who have had bad experiences with law enforcement, and they tend to have a rough time. We have an officer, and you probably know him, Moses Castillo, that will come in, and he knows how to de-escalate that, and he handles it well, and he shows emotion when he talks, and that really helps to do that. But yeah, we have had that. It depends on what group it is, but we have had that where there's already, and right now even more so. I worried about it now that we did that, when everybody's finding all of this going on. And the one thing I told him was stay focused, keep doing what you normally do, talk about your situations, and make sure you don't go off track on anything, because it can go that way very easily. And so no, it went really well. I was really glad, because yeah, right now is really hard to bring in law enforcement. They're going to be talking to you. You've got people in there that are just like, no, I don't want to hear from them. Yeah, it's challenging right now, but it went well. I have to say, it went pretty good. And I was in group 8, and we talked about probably more challenges if we have to go into the police stations to make reports with people. If we do that kind of accompaniment, that's what tends to be a little more difficult, because that's when they'll tell you, can you just wait here? Or they'll bring an officer to the lobby to hear the story. And that's the challenging part. I think I feel better control when we're in an accompaniment, because you pretty much, most of us, as far as our nurses, are on our side. So, but yeah, that's kind of what we're seeing.
Yeah, and because of our last session, we were so jam-packed with our last session, we didn't get a chance to have a conversation about your organization's relationships with law enforcement. But we're at a critical moment for our movement and the field in terms of our ongoing relationships with law enforcement. And defund the police. This is one of those areas where we are compelled to work with law enforcement, and it would behoove us to make it as positive and smooth an experience as possible.
Yeah.
Nevertheless, we also know that we're going to have trainees who have their feelings in this moment in particular about the role of law enforcement, and historically how they have or have not treated folks in our communities, and then perhaps specifically in working with survivors, right? We've been talking to the rape crisis centers up and down the state, and easily probably half still have not rosy relationships with local law enforcement. I even think that some of you mentioned in the last session how you had law enforcement that still were, I don't know, not giving correct information, or trying to separate the advocates from the survivors, if no other reason because they didn't know the law. We can spend 3 minutes having a conversation about, how you all are anticipating working with your trainees around, kind of current hostilities that we may experience with some of your upcoming trainees towards law enforcement. I mean, Sonia just expressed, a situation with her last training. I wonder if anybody else is concerned at all about how you're going to handle this part of your training, especially with having either law enforcement officer, somebody from the assistant, from the district attorney's office or the city attorney's office, if you have a city attorney's office as well. Anyone have any kind of like, gee, I'm wondering how I'm going to handle this, or is it just going to be business as usual?
So this is Veronica from CBS. So it depends on the police jurisdiction. So we have 16 in Contra Costa County, and we also do Marin. So it honestly just depends on which jurisdiction. We have a advocate in Richmond Police Department. And so
they have like a desk or a room.
Yep.
Okay.
So they're used to us being around. We've had a good relationship with them for a long time. However, you know, with other jurisdictions, I think there's a mistrust on both sides. And I've been with CVS for about 20 years, but I wasn't here full time. So I just came back full time. And it's been, and over the years, it ebbs and flows. It depends who's in management in the different police departments. So when we do have trainings and there is a volunteer or a staff person that has a very hard time with law enforcement, you know, I really ask them that if they're able to separate their personal viewpoints, because it's not going to support the survivor if they have a caustic relationship with law enforcement. While I may feel that they do a lot of things wrong, it does not going to help if I say that to them constantly. It's not going to move forward the trust. So I think it's like a relationship. It's always been challenging. Now it's really challenging. And, you know, unfortunately, there is systematic racism and inequality in the police departments. So that's why we're there.
Ooh, well, Jose's sheriff recently stated that systemic racism does not exist.
Right.
Jose, oh gosh. Jose, oh dear. Jose, can you share a little bit more about that with us?
We've been recently invited to join several community task force addressing different aspects of the economics of institutionalized racism, etc. And as we were getting ready to go into the meetings, this statement came out, and we were stunned. And everybody in the room just kind of fell silent, and it's like, oh, well, we thought we were starting over here, but I guess we're starting over here.
Wow.
Yeah, we're looking at it from an entirely different viewpoint. So it isn't we can't even start with repairing the damage if someone won't admit that there is damage.
Right.
Yeah.
Right. If they won't even acknowledge that the damage exists, you can't repair it. Okay. Well, you know what? I wish you a lot of luck.
Thank you.
Let us know. You know, you could. I don't know that there's much that CalCASA can do, but you know, we're working on that also in terms of messaging, positions, ways to articulate that kind of how to nuance those conversations with folks who don't believe that it exists. It's like people who say, I don't see race, I don't see color. It's like, well, then no wonder you don't see the racism, because if you don't see the race, then you don't see the racism, right? So yeah, so that's it's unfortunately not that uncommon, actually. And Michael shared that you had a situation where a law enforcement officer tried to talk a survivor out of testifying because it would ruin the life of the assailant if he went to prison. And you know what? That is a reality, particularly in communities of color, right? Where we know that there are a disproportionate number of folks, Black and brown folks or folks of color, who are swept up or caught up in the criminal justice system. And that is something that survivors will struggle with. Engaging the criminal justice system is something they will struggle with because they don't want somebody to get a second or a third strike, or because they don't want someone to go away forever, or because they don't believe that the criminal justice system really is there to protect them or advocate, be a place of recourse for them. So I'm not, Michael, I don't know what the particularities were of that thing, but it is not uncommon for us to have survivors that are just like, no, going the criminal justice route is not an option. It's just, and your advocates will need to respect that, right? They will need to, on some level, have an understanding about why folks will not want to go the criminal justice route, right? And not push it, right? Which takes us to, if there aren't any other comments around, the question with that unit, I'd like to go ahead and move on to Unit K. Or are we taking a break? We taking a break?
It's break time.
It's
We'd like to
break
give folks
time.
a quick 10. So we will come back at to 24, and then we will jump into Unit K.
And then let me just say this, that before our break, to cut into our break time, but at some point, if you all deem it helpful, maybe we could have a session where we're just talking about how we're going to manage our advocates and working with local law enforcement in this particular moment. I mean, we have a lot of extra pressures, including COVID-19. And, you know, kind of like we say we have two pandemics going. We have COVID-19 and a racism pandemic happening at the same time, right? So, you know, if you all deem it that it would be something that would be beneficial just for us to get together and figure out, you know, how we can, you know, come up with talking points or ways to address these kinds of things as we do our advocacy in our communities with local law enforcement and our criminal justice system, you know, let us know. Drop it in the chat box if that's something that you think would be helpful. Okay, sorry. Sarah, do we adjust our break time, return time? Okay, so we're back in 10. Thank you, everyone.
We're good. Thanks. Okay, welcome back. Hopefully everyone had a good break. We are going to move into the second half of our program here. So we're going to dive into Unit K, which is Agency Procedures and Requirements. The time to complete this unit is 2.75 hours, which is kind of a odd number, but that's what it is. The media allowable for this, assuming you're doing 10% of overall media, would be 16.5 minutes. And unlike legal in court, this last section here does not require a subject matter expert. So kind of the overall idea of this unit, what we want volunteers to be walking away with, is advocates should be able to describe the framework within RCC services are provided. So including things like your agency policies and procedures related to advocacy, of course, even things like funding requirements, legal issues, and your relationship to community resources as well. And additionally, advocates should be able to identify the administrative and training requirements, everybody's favorite topic, of the sexual assault victim advocate position, including the need for accurate documentation. So a lot of this is going to kind of be specifically around what it looks like for your agency, for your service area, but we will kind of cover some of those high level points, things that folks should be thinking about for the training standards for their agency procedures. Lee, I'll hand it over to you.
Yay, okay. So this section is going to be pretty brief. But, you know, this is probably actually where a lot of, okay, I just make sure, sometimes I forget to unmute, sorry. This actually is where many of you actually probably start your counselor advocate training, right? This is who we are. This is our agency philosophy. This is what we do. This is how long we've been around. Maybe a little bit of history with your organization, or the organization's history, and you know, your service standards. Like, this is why you're going to get a training from U through K, right? You're gonna get this training through U through K, and then you want to make sure that, and explaining that, the spirit behind explaining that with your advocates really has to do so that they have a very comprehensive understanding of the spirit behind all of this training content, as well as the particulars, right? So you're going to get this solid training on units A through K, and this is why, right? So that they have an idea of what to expect and how important this is to the certification of the Rape Crisis Center and the Rape Crisis Center and the Sexual Assault Program's ability to operate as a certified organization and have the advocates actually have confidentiality, and so on and so on and so on. So you want to make sure that they understand the big picture, 30,000 feet, right? You also want to make sure that your agency philosophy, right, or that the people who you're recruiting to go through your training, that their values and their personal philosophies jive with your organizations, right? So the most common example that we use for that is you know, you're introducing or inviting people to become part of the family of your organization, and you're going to put them through this training. You may have a conversation about the very kind of political nature of gender-based violence. You want to make sure that people understand, if that is the position of your organization, that they are in alignment with that thinking. My organization that I worked at in Los Angeles was, we very loudly and proudly stated that we were a pro-choice organization. And this is why we are pro-choice, because survivors need to know that in the event that, you know, a pregnancy occurs as a result of assault, that they, as part of their options towards healing and recovery, includes termination of that pregnancy, right? And if you personally do not agree with that, can you compartmentalize that and advocate on behalf of the philosophy of the organization, right? So you have that conversation with folks so that they understand, again, they are representatives of your organization and your organization's reputation. They are ambassadors for your organization, which means they have to be able to get behind the philosophical aspects and the values of your agency. They can't get on the call and or get in person with somebody at the hospital and tell them, we're going to do all this, but you don't want to take that morning after pill. You don't want to do that if your organization is a pro-choice agency, right? So you got to be real clear, make sure that they are in sync with your organization's values and philosophy and principles and what have you. This sometimes becomes a weeding out process. This becomes that conversation sometimes is the opportunity for people to see their way out the door, right? But you want to be real clear with folks, because you don't want anybody out there speaking on behalf of your agency misrepresenting what your organization stands for, right? So this conversation is really important, because, you know, you're trying them out also, right? They're trying you out, but you're trying them out also. We want to make sure that this isn't going to become a problem down the road. So that's why I say this is where a lot of people start their trainings, is right here, is with the service standards, agency philosophy, as well as the agency limitations. There are things that our organization cannot do or will not do, right? There are things that we cannot do. And so you want to make sure that they don't go out there making promises on behalf of your agency that your agency cannot fulfill, that they are prohibited from doing, like making child abuse reports where they're not supposed to, right? Because that will then jeopardize the organization, may jeopardize your funding and the like, right? So they need to understand that they are extensions, ambassadors, right, for the organization and all that great work your agency has done over the years, right? So they need to know that they are joining an already existing movement, right? And that they have to get on board. Okay, so you want to make sure that they get that, and that they're able to separate their personal views if they are not consistent with your agencies from that of the organization. They need to know how your agency works, right? It's just clear that they need to know how the organization works. If there are protocols that are in place, if this happens, you call this person, this person. We have a phone tree. Here's the phone tree. This is what you call in this case, in this case. Sonia brought up how sometimes religious views get in the way of people's ability to support your agency, or vice versa, right? Excuse me. So you want to make sure you're clearing all of that kind of stuff with your agency, right? with your advocates. They should know where your funding sources come from. You know, combinations, federal grants, state grants, local grants, private foundations, fundraisers, and the like. You never know. They might have access to other resources that you could apply for. So they need to understand how the fiscal part works. I'm not saying you have to share the overall organization budget or, you know, or people's compensation. That's not what I'm saying. I'm saying that they need to understand that you are, that you rely on public dollars, right? And because you rely on public dollars, that your organization has to be a good steward of those public dollars. So when they're like, well, why can't we spend money on this? Or why can't we do that, right? That becomes one of those understanding how your organization works and how funding works will help allay some of that kind of, kind of thing. Client documentation, right? We have to keep data. We have to keep records, right? But because records are subpoenaable, right, we want to make sure that we are doing our record keeping in a way so that it does not increase vulnerability for the survivors. Right? So when you're doing your training, your advocates, you're training them how to fill out their fact sheets or whatever kind of documentation system that you have, that they are being trained and equipped to complete that information so that it does continue to maintain the confidentiality of your survivors, and that you understand that that information has to be kept in a locked space. Not everyone has access to it. And you really want to ensure that notes and records will not reveal anything damaging about your survivors, right? And so there's even some examples in the advocacy manual, the ones that support for survivors, on the difference between, really good notes and not so good notes, right? So we have some examples in the manual that the advocates will get, but that they understand that you will be keeping records and how to do that record keeping in a way that maintains confidentiality because there's always the potential of being subpoenaed. Okay, is there a another slide? Okay, out of with a lot of the conversation around confidentiality and reporting and all that good stuff, 1035 is the one that talks about our confidential communication specifically. So if, again, with your cheat sheet, the little card that they're going to get to, maybe it's a 3-fold card, however you want to do that, or maybe it's something that they keep, maybe it's an app, or maybe it's something that you create that they can keep on their phones or what have you. But it makes sense that you would put things like 261 on there and all the different kinds of permutations of 261. You also want to have 1035 on there that is explicit about confidentiality and privilege, and the survivors maintain, it's the survivor's right to the privilege, right? So that you can reference that. And it's, again, as your advocates are talking about the survivor's rights, okay? And then your volunteer time documentation, please, 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 this has always been kind of a nightmare, but please, 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 you want to make sure that your advocates understand how they have to document the time that they are contributing to the organization. I don't know if they're staff or if they're volunteers or combination, maybe they're stipend in some way, but all of the work that you have volunteers that are doing, make sure that you're capturing that in some kind of a systematic way, right? Make sure that your volunteers are reporting that they did the shifts at this time, or that they showed up and they stayed from this time to this time, because all of that will count towards your VOCA match, right? So you don't make sure I know sometimes we feel like we're running around chasing after them and trying to get them to do their documentation. Maybe create some kind of maybe it's a Survey Monkey thing where they just get a link and they just go in and they say how many hours they've done, that they get you set a timer so that they get a notification that they have to go ahead and fill in their hours, so that, again, you don't want to be missing out on your VOCA match for that. So make sure that your advocates understand from the jump, when you maybe link it to that conversation around organization funding, right? Maybe have those conversations at the same time. Wow. Are you serious? Jose just dropped in the chat that Mark won an award for over 1,000 crisis line hours last year. Holy mackerel. That's amazing. Congratulations. Mark had to take off, right? But you make sure you tell him that we said that's amazing. That is absolutely amazing. So yes, you definitely want to, oh, there you are, Mark. You definitely want to keep track of those hours, because that is part of, that's going to help sustain your organization. And you never know, you can get real creative and and maybe use that as part of a fundraising campaign, right? So just I just remember when I was a volunteer how much I hated keeping track of my hours. You let them know from the jump that this is an expectation, this is part of the job of being the advocate, of being a volunteer, that they must let you know about their hours, right? So, but you do want to make it easy for them to do it. So, like I said, if you want to fill out a SurveyMonkey something, create that so that all I have to do is log on, say I did this from this to this time, and then you can process all of those numbers at the end of every month, or for all of your reporting purposes, because you need that data for when you're doing your reports for CalOES as well. Okay, I cannot emphasize that enough. Make sure, because then you'll be running around chasing after them, trying to get those numbers, and that is a pain, right? So make sure your advocates right up front, they understand the importance of that. And maybe you may have to even incentivize them to do that. So, if you get them in before 5 o'clock on Friday, you get an extra Starbucks coffee card or something like that. But I'm just saying, you wanna, if you have to incentivize people to make sure that make sure that they're doing it. Okay. Okay. Next slide, please. Okay. Anybody ever have problems with collaborative partners? Anybody? Bueller? Anybody? Anybody have problems? You can go ahead and unmute if you have. Oh yeah, Sandra Ibata, you have bilingual volunteers that average about 1,000 hours in a year. That's amazing to me. That's like a full-time job. That's almost close to like that's a lot of time. So you guys are rocking. That's kind of amazing. Anybody challenges with collaborative partners or with?
Say DA's office OAs and mandated reporting.
Wait, who said that?
That's Louise, the DA's office and mandated reporting issues.
What happened? Can you tell us briefly, like what's going on with that?
We are going on year 3 without an operating agreement.
And is that because of your non-mandated reporter status?
Yes, and in fact, we offered to put language in that those staff members who were mandated reporters or in mandated, would report, because obviously the therapists need to be mandated reporters, and that language wasn't good enough. So I'm hoping that it will get fixed because they've just brought in a new DA, but it's been really miserable because I have to keep on saying, I'm sorry, we keep on trying to get that operating agreement.
Man, well, I hope that is staff that is working with the DA's office and not, if you have a volunteer or anything like that, right?
No, and actually we've worked with you guys and CPEDV.
Okay. All right. Yeah.
Everybody else, but yeah, that's been our only perennial, like in the last few years, collaborative partner issue. Otherwise, most of them have been pretty cool. The only other one that's been an issue is our local Child Abuse Prevention Council, because they are also funded by the DA's office and they don't want to make any waves.
Interesting.
Because they're getting, because they're also part of that and they are getting county money and they don't want to offend anybody on the county. So we don't quite get the backing we could.
Okay. By statute, even though by statute to do it, it's like, okay, all right.
We've brought statute. They actually, it was so bad at one point, they accused our executive director of caring only about the money. When we said that our CalOES victim services funding is dependent upon us having an operating agreement with you, and the law per the penal code states.
Look, we don't care. We have our own little fiefdom over here.
Yeah.
Well, and again, that's a kind of problem with a collaborative partner or a community partner, whatever, that your advocates need to understand what the protocol is in your organization. That if there are any challenges when they're out there with the multidisciplinary engagement, if they're on a college campus, if they're working with nurses or saying as safe nurses or with cops or whoever, if it's the military, whoever, a local K through 12 school, businesses, whomever it is, if you run into problems, your advocates need to know what is the protocol for handling problems with community-based partners.
Agree, and we've tried to make the protocols be, you know, send it up the chain. You know,
And yeah. I mean, with
like,
the child, that's what we used to tell them, is to just call your volunteer trainer. Just call the trainer.
exactly.
Don't even just say, okay, sorry very much, thank you, no problem. You find your way out of that conversation, and then you get that information to the someone on staff at your agency.
Exactly.
Or whatever your process is, however much latitude or authority your advocates have when they're out and about, you want to make sure that there is a very clear process or set of protocols for managing those problems, because your reputation, and once people start talking about you out there in the community, you know, it's just amazing how much cleanup you could be required to do. So make sure you're talking to your advocates from the jump about, this is how we solve problems. Do not deviate from these protocols.
Yes, I think we have not had too much problem on the advocate side, and well, and especially not this year with COVID, because a lot of our volunteers are doing Second Life work, and they're vulnerable and not able to go out, you know, and attend, even for the things that are open.
Well, you know, Mark has a suggestion here. There is a state DA's association, California District Attorneys Association, CDAA, and he's suggesting that maybe having a conversation with them about working with your local DAs. So that might be an option also, if they're not giving MOUs as a result of your unwillingness to be a mandated reporter, because statute prohibits us from doing that, right?
I know, it's like, we would love to be that, but the law says no.
So, okay. And then cranks, pranks, sex callers, people, how, you know, just some ideas about how you all manage. Do people still get those kinds of people calling on their hotlines? Do the cranks still call? And the pranks?
Yes, we have one right now that keeps calling, and it's a male, and he keeps calling and calling. And, you know, the last time I got him, I told him, you know, I know you're, you know, because he starts telling you the story of the, you know, I won't go into that, but you know, I let him know, you know, I have your number, and if you continue to call, he goes, well, I was looking for help. And I says, we've offered you help every time you've called, and that's not why you're calling now. And so I have your number, and now I'm ready to report you because you're abusing this hotline. And yeah, he still calls, and it's really irritating, you know, because, you know, if I could get him all the time, I could handle it. But the thing is he calls at different times so he can get different people.
Right. Oh man, they know, they would know the shift change. They would know when a new counselor was on call.
Yeah.
You want to make sure that you are being honest with your advocates about the pranks and the sex callers.
Yeah.
And that this is something that, that they will encounter, not to expect, but that they may encounter it. And then you also want to make sure that you internally have, like, your in-services, an opportunity for, or a way for them to debrief and kind of like expel that experience, because you can get sucked in for a really long time before you realize who this is on the other, what they're doing, right? So you want to make sure that as you're doing your training with your advocates, that they understand, you know, if you can tip them off, you know, these are the tip-offs, right? Heavy breathing, yeah, it's all right. But I'm just saying that there are things that they do that are in common, and if you can tip them off, great. But then you also want to make sure that you have a process in place for them to debrief should they get conned by one of these folks and they feel yucky and dirty afterwards. But that there is a process for dealing with you are required, according to CalOES, to have a conversation with your advocates about cranks.
Yeah, because they want, the clue, one clue is they want to go into the story right away. They want to go into the story. It's not about, I'm feeling like this, I'm having trouble. No, it's right directly into the story of what is going on. You know, so that's a big clue.
Mark makes a good point. Mark,
automatically.
Mark, are you, thanks, Sonia, appreciate that. Hey, Mark, are you able to elaborate a little more on your, you know, the sameness by which we need to respond to these folks?
We had a male caller that about a year and a half ago, 2 years ago, was calling quite frequently, and it took about 3 months that when the staff, volunteer manager, and the rest of the staff got together and came up with a policy on how to end the call. And then at every in-service it was talked about, and then after that, then the caller realized he wasn't going to get what he wants. He was going to have a very abrupt end of the conversation, and it was interesting. After a while, he knew what my voice sounded like when I said, "Hello, my name's Mark," and he would just hang up. Okay, so he knew that he wanted to talk to a woman, not a man. Okay, and so anyway, yeah. So it took a little while, but now he just kind of realized, I'm not getting what I want. I'm not getting what I wanted. So then he kind of just disappeared, and he hasn't showed up recently. But
and that's so important that you internally share that information, because people will be like, oh, I had that guy, oh, I had that one too. And that you have a saneness about the way in which you end the call, because if some of your advocates give them more time than others, then they will keep calling and thinking that they can push the envelope and get that same kind of reaction or response from other advocates. So it's really important. Can you briefly share with us, like, what's the, how do you drop the hammer on these people?
Well, in the end, after that 3 or 4 month period, once you heard his voice, you could just hang up. Say, I can't help you anymore, I have to hang up. And then you would hang up. But the executive director sent out an email saying that it's okay to end the call abruptly. So then it just was reinforced. The corporate knowledge was reinforced, and then that was important.
And hopefully your EDs and your CEOs support that. I can't imagine why they wouldn't, but hopefully they support you're going, not today. Click, You cannot give them any time. You cannot give them any air, right? Was it Frank? was his name Frank? I'm just saying. They want to know if it was Frank. You don't have to don't answer that.
Actually, yes, it was. Yes, it was. Yes, yeah.
I think we've all had a Frank, on our hotline calls. Okay, very good. So really important that they address the problems. You don't want to make things worse. So your advocates need to be on board, and they need to be given a heads up. It's only fair to give them a heads up about the cranks and the chronics and the sex callers. So, and do we have one more slide, Sarah? Okay. What happens if you are excluded from, an exam, something that which the survivor is entitled to by right, right? Don't want to get into power struggles, but you do want to make sure that your organization has a policy for how to handle these kinds of situations, right? Katie says you bring up the penal code. Well, according to penal code, blah, 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 the survivor is entitled to have a victim advocate and a support person, blah, 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 be present, right? But you want to make sure that you have it very clearly outlined in such a way that your advocates are very professional about how this goes down. And if they persist, what is it? How many times do they bring up the penal code? Do they try and talk to the survivor one last time before such and such happens? What are the parameters? What are they allowed to do? And before they call you on the phone and say, I'm being excluded from this kind of an interview or this kind of a process, right? So in the chat, if we could, if you could just drop in the chat, like, if you have creative or even not so creative approaches to solving that, let us know, because your peers can all learn from each other. If they still don't want to cooperate, then call the program director. So you bring up the penal code, and if they still don't want to cooperate, you call the program. Do you call the program director in the moment, Katie? Katie, can you help us with that? Do you call them in the moment and say, hold on, please, and then you call, or do they leave and then it's something that's, you get all of the, you know, identifying information and then you call later and file a complaint? How do you?
If there's time, I would definitely step away and say, I, need a few 5 minutes, and then I would give my program director a call. Our law enforcement's pretty good. They understand what's going on, so we don't really have this issue. But if that was the case, that's what we tell our advocates, is just to bring up the penal code. And then at that point, if they don't want to cooperate, then, call the program director and go from there and see what, what they say.
Mm-hmm. Mm-hmm. Okay, good. Louise says that you were recently excluded from a SART because they wanted a mandated reporter. What, Louise? Can you tell us quickly, briefly, what went down there?
I found out about that with our XS report, progress report. That was the first I heard of it. The SART advocate was out on maternity leave, so I think had she been here, she might have pushed, she might have pushed harder, but it was while she was out. And they said, well, we're just going to have somebody from the victim witness advocates in the DA's office show because we want a mandated reporter. And my point is like, SANE is a medical professional, mandated reporter.
Yeah.
Like, and let's be real, we already know that the person is underage. That's been well established. So that was there. The law officer is present. It's like, do none of these people file reports? Are we the only people that file reports?
Wow, that is odd.
Odd.
Like,
it is so weird. I mean, that whole mandated reporter thing has gone just in such a bizarre direction. I mean, we've had agencies told that they couldn't work with us or see us. We have been not permitted to be in the JDF, which means that the JDF kids can't make PREA calls.
This is very.
I mean, and so like, I don't want to make things worse now, because if the new DA is going to be reasonable, then maybe the problem will go away. But I was shocked. I've heard of other people having issues with, with law enforcement or with DAs in their communities. And up until that, we really enjoyed a good relationship with the county and with the DA's office. But we were, I mean, it was like they went to a group home. And somebody said, oh, wait, you can't be, we were called out. And then they said, no, you can't be here. And they escorted her out like a perp walk and a wall of other people. So the kids who already knew the advocate, couldn't see her. She's like,
wait, which county are you in again?
Placer County.
This is very bizarre.
I mean, the way it rippled out starting with the, hey, guess what? We're not a mandated reporter when we're doing our rape crisis advocacy work. The way it rippled out and the harm that has happened, within, it's not so much a public issue. It's not something that's coming out nastiness with the public or with the community that way, but internally it's been very strange and a very long road.
Is anyone else having problems with their DAs or their SANE or SAFE nurses or anything like that? If so, if you could just drop it in the chat, that'd be great. It could just be your particular administration. So if you're getting a new DA, maybe that will all change.
Well, I'm hoping that maybe that's why the old DA retired with 5 days notice.
Girl, you got issues.
No, I don't have issues.
Yeah, you guys has got issues. Yeah. Okay, so we're nearing time. Just want to make sure that you have a process in place and your folks know what to do if they are excluded from a forensic exam or from a law enforcement interview or anything like that. Okay, this has been real. Really enjoyed it. I hope you all join us for our next round of trainings. We have some we have some trainings coming up on mandated reporting and confidentiality and mandated reporting coming up on the 18th. We also have one on working with the trans, Latino, and gender nonconforming communities. But you'll be getting notices and emails for those also. But I'm wondering if there are any questions or comments or things that you want to ask your peers, because your peers are really some of the best ways of learning about this stuff. Anyone have any questions or anything that they need some insight on. Oh, thank you all very much. Really appreciate it. Make sure you take the survey, and you'll be hearing from Sarah again about, because we are, like I said, we are in the process of putting together an actual training curriculum to aid and assist everyone in how to actually implement all of this content with your advocates. We really want to lift up and honor the work that you all have already done. So if we could just kind of become this clearinghouse for a bunch of different activities that people have used, we would love to do that as well. And so you'll when you get that email, see that email come around. If you have access to your training materials and you would like to share them with us, that would be awesome, because everybody, we're all trying to figure out, how do I do this now? Or now, how do I do it online? And what have you. So you'll be seeing that solicitation coming around again. Anyone found the video for compassionate care? Wasn't that through the DA's office, Sarah? Didn't we? You can order through, I want to say it's CDAA is one place where you can order that. That's
yeah, I was actually just putting it in the chat. So the only place that, at least as far as I know, the only place that you can get it is through the California District Attorneys DA's Association, or just not DA's twice, California District Attorneys Association. And they don't have a digital version, even though it's 2020. I can only guess it's because they really want folks to pay like the $22 to have the DVD shipped. And I know this because I researched extensively last time I needed it, and ended up having to buy a DVD player special so that we could show that very video.
Well, you know what? Maybe we should figure out a way to see if we can do it, if we can get them to do it, make it streaming.
Yeah, get them, you tell them we need it.
We need it because people are training at home, and yeah, so maybe we'll have that conversation.
That's a good point, actually, the training at home. Yeah.
You know, any other last minute questions? If not, I want to thank you all again for spending this time with us. Really appreciate you and all of your hard work. You should all be very proud of yourselves and contributing, and thank you all so much for your comments that you've dropped in the chat box. These recordings will be available at some point in time on the hub. It'll take us probably 3 weeks to get them edited and clean and pretty and upload it so that you can revisit the content as well. So Sarah?
Nice hanging out with all of you. Thanks for coming. And just a reminder that we do have the first half of session 1 recorded, and I sent that out to folks who are registered. So you should all have it. It isn't posted anywhere yet, but that does exist because we wanted to make the regulations and the application part available right away. So yeah, please reach out to one of us if you need it, can't find it, although you should have it, or if there's other folks who you want to share it with. We just need to get that posted, but that part is done, so just FYI.
And they can find that on the hub? Or you emailed it to them?
I emailed it to them, yeah.
Very good. All right, excellent. Everyone, please take good care of yourselves. Go do some self-care. Have a fantastic weekend. Drink lots of water. Keep washing your hands. Wear your masks and social distance, and we'll see you next time. Thank you.
Thanks.
Bye.
Bye now.